But the fact remains that the trial court would proceed to frame a charge against him like this. Kindly turn to paragraph 4 at ink page 10, my lord. This is the charge which came to be framed against him. That on the above said date, time, and place, you all the accused being the members of an unlawful assembly came with a common object with deadly weapons and stated above, and as stated above, when deceased Yogesh Gowda came to his gym named above, you all accused 1 to 6
chili powder.
ಅಲ್ಲ ಕೋಲ್ ತಗೊಂಡು ಬುರ್ರೆ ಹೊಡೆದಾಕ್ತಾನೆ ಅಂತ came with an intention to murder the deceased Yogesh Gowda, poured chili powder on the face of deceased Yogesh Gowda. You accused number 2 stabbed the deceased on several occasions with jambe on his stomach. You accused number 3 assaulted with the coyote on his head. You accused number 1 assaulted with the rod on his head. You accused number 1, kindly mark this, my lord. You accused number 1 assaulted with stick, and you accused number 6 assaulted with long on his head and also other parts of the body of the deceased and caused the death. Well, what is attributed to the first accused in the charge that is framed on 14th of September 2017 is that he made use of a club and gave a blow on the head of the deceased. Well, your lordship would get from the postmortem report, which I have also placed on record in the case, my lord, that the skull has been broken. Well, the cause of death is the cumulative effect of the injuries which the deceased had sustained. Therefore, my respectful submission to lordship is, at this point of time, you can't say that he is not the principal accused in the case, and his culpability is certainly lesser than the culpability of.
Now, in the charge sheet or charge framed by the CBI, this is not against accused number 1.
No,
He is only charged of conspiracy.
Additional charge.
Additional charge.
Additional charge. My lord, after the CBI filing of the charge sheet, my lord, the additional charge is only vis-a-vis, let me submit to your lordship, with regard to the offence under the provisions of the Arms Act. Excepting that, nothing else. Earlier, my lord, before the Dharwad court, my lord, a charge for an offence which is made penal under the provisions of the Arms Act was not there.
That is added.
That is added. That is the additional charge. Well, kindly go to the charge which came to be framed. Even in the CBI also, they would say, my lord, this is what he said. Page 26. Have a look at page 26, my lord. Well, probably with the aid and assistance of 120B, or with the aid and assistance of 149, or with the aid and assistance of 34. Kindly go to the last 3 sentences at page 26, internal page 10. In furtherance of the criminal conspiracy, you accused number 1 to 16, accused number 18 and 21 have committed an offence under section 302, that is section 120B. Therefore, even in the additional charge sheet that has been filed, the investigator does not exonerate the first accused having committed an offence which made penal under section 302 with the aid and assistance of section 120B and 149. Well, the next submission.
Yes.
Well, the next submission is 463, 464, and 465.
Curable defect.
No, sorry. I will kindly read 465, my lord, first. Is it a court? Well, the matter is now being agitated before your lordship, which is not a court of appeal, which is not a court of confirmation, which is not a court of revision. Have a look at section 465. This is in relation to a judgment, conviction, sentence, and order, not in relation to an order passed on an interlocutory application. Have a look at 465. My learned friend invited my lord's kind attention to section 465.
Yes, sir.
Finding or sentence when reversible by reason of error, omission, or irregularity. Subject to the provisions herein before contained, no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation, or revision on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceedings. So this could be pressed into service only after the disposal of the case and upon conclusion of the trial, when a judgment of conviction, sentence, or order, but he refers to order, judgment of conviction, sentence, or order, because in that judgment of conviction, there will be an order. Just like, my lord, for example, awarding of compensation under section 357. Well, it is only the judgment that could come, 357. For example, my lord, in a proceedings under section 125, an order is passed. Now, this is vis-a-vis the judgment of conviction that is passed in the case. Conviction, sentence, order passed upon conclusion of trial. Well, otherwise, 465 does not come into play. Now, may I request your lordship to kindly go to 400, and he also read to your lordship, 460.
Irregularities.
Yes. While inviting my lord's kind attention to G. My lord, 460, if any magistrate not empowered by law to do any of the following things. This is not a case where the sessions court or a magistrate is not empowered to record the statement under section 306. Does this, that means he records or gives a pardon to the accused under section 306. So 460 will have absolutely no application vis-a-vis section 465 would be my answer to the submissions which came to be made by my learned friend. Well, now, he submitted to your lordship that there is no provision in the statute or a condition that is imposed in the statute which says that unless and until that the evidence of the approver is recorded, it is extremely difficult for the prosecution to make out a case against the rest of the accused. Well, here again, first judgment of the Supreme Court is in Lieutenant Commander Pascal Fernandez. Well, I shall take your lordship a little later. What is his plea? Or when the prosecution was called upon to have its say, the prosecution also does not contend that it is just not possible for it to bring home the guilt of the companion accused of the first accused in the absence of his evidence. That is what is needed, without which, my lord, pardon can't be granted. May I request your lordship to kindly turn to Pascal Fernandez. Kindly pardon me for a second. May I request your lordship to kindly, this is in 1967 Supreme Court cases online, Supreme Court 37. May I request your lordship to kindly go to paragraph 15. Kindly permit me to read to your lordship. It's a very small paragraph. Paragraph 15. In this case, the special judge made no effort to find out what Jagasia had to disclose. The English law and practice is to omit the proposed approver from indictment. B, to take his plea of guilt on arraignment. Or C, to offer no evidence and permit his acquittal. Or D, to enter a nolle prosequi. In our criminal jurisdiction, there is a tender of a pardon on condition of full disclosure. Tender of a pardon on full disclosure. Section 8.2 of the Criminal Law Amendment Act is enabling. Without recourse to it, an accused person cannot be examined as a witness in the same case against another accused. to determine whether the accused's testimony as an approver is likely to advance the interest of justice, the special judge must have material before him to show what the nature of that testimony will be. Ordinarily, it is for the prosecution to ask that a particular accused out of several may be tendered pardon. But even where the accused directly applies to the special judge, he must first refer the request to the prosecuting agency. It is not for the special judge to enter the ring as a vertebral director of prosecution. The power which the special judge exercises is not on his own behalf, but on behalf of the prosecuting agency, and must therefore be exercised only when the prosecuting joins tendered pardon, because it does not need approver's testimony. It may also not like the tender of pardon to the crime or the worst offender. Well, this would be very, very important. The proper course for the special judge is to ask for the statement from the prosecution on the request of the prisoner. If the prosecution thinks that the tender of pardon will be in the interest of a successful prosecution of the other offenders whose conviction is not easy without the approver's testimony, it will be indubitably agree to the tendering of pardon. Well, they must contend when the court calls upon the prosecution to have it say on the application of the prisoner and file under section 306, the prosecution must contend that without his evidence or testimony that is going to be recorded, it is just not possible, or it is extremely difficult for the prosecution to bring home the guilt of his other companion accused. In the case, he is law laid down by this, a full bench of the Supreme Court in the case of Pascal Fernandez. Well, the next judgment is, well, the earliest judgment, what he has referred to, my lord, is virtually per incurium. In view of the full bench judgment of the Supreme, he has referred to two judgments. One of this court, my lord, his lordship, Justice Kudur, speaking. Yes, I think my learned friend would, Mr. Sandesh will deal with it. And ಆಮೇಲೆ ನೋಡ್ತೀನಿ ಇದೊಂದು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ನಾನು. ಆಮೇಲೆ on this point, whether there should be a plea that it is not possible for the prosecution to bring home the guilt of the companion accused of the witness, well, the application could not have been granted by the trial court, it is down by the Supreme. May I request your lordship to kindly turn to, in Suresh Chandra's case, my lord, this is 1995, volume 1, SEC 80. ಅಲ್ಲಿದೆಯಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಚೌಟ ಸರ್ ಕೊಡಿ ಇವ್ರಿಗೆ ಕೊಡಿ ಸಾಹೇಬ್ರಿಗೆ ಕೊಡಿ. Well, may I request your lordship to kindly turn to ಎಲ್ಲಿದೆ ಸರ್ ಯಾವ್ದು ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ ಪೇಜ್ 80 ತಾನೆ ಪೇಜ್ 80 ಮಲ ಸಪ್ರೇಟಾಗಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಇದೆ ತಾನೆ